Good afternoon, friends. My today's topic is effect of pendency of cases, we can say workload, and frequent strikes by our brother. So this was the case in professional ethics of advocate on record, which I am going to share. The title of the case is Krishna Kant Tamarkar versus State of Madhya Pradesh 2018. Friends, the exploration of sections that were in the FIR were 148, 149, 302 of the Indian Penal Code. This case arose from bail application, which was frequently dismissed by the Honorable High Court, as the person was convicted by the trial court and he was even jailed for the last 10 years. On one side, there was too much workload on the Honorable High Court, due to which it was taking time to decide his appeal. And on the other side, the work of the High Court was disturbing due to frequent calls by the bar associations. So this is very important case. Be connected, be settled, and please listen up to the end of this video, and please do not skip in between. So friends, there was bail application. Appellant applied for bail pending consideration of appeal before the state of Madhya Pradesh. High Court rejected his bail application. He again applied. Again, the High Court rejected bail application, and with the observation that evidence on record did not warrant grant of bail. So this order of the High Court was challenged on the ground that appellant had been in custody for more than 10 years, and remedy of appeal would be meaningless if he had to remain in custody for the full term. So this was the issue. The law points which were considered in this appeal or which were raised by the appellant, first one was whether, having regard to the nature of present volume of work, expectation for speedy disposal of criminal appeal was realistic, or there need to be re-engineering of the total judicial structure. This was the issue. Now, friend, let us explore brief facts. Then we will explore what the court held, what directions court gave to streamline its functioning. Friends, I already told, appellant was convicted under section 4, 148, 149, read with 302 of the Indian Penal Code by the trial court. Appellant applied for bail pending consideration of appeal before the Honorable High Court. His prayer was rejected. After few time, another application was filed, and again it was rejected by the Honorable High Court. But while rejecting second appeal, High Court gave observation that evidence on record did not warrant grant of bail. This order of the High Court was challenged on the ground that appellant had been in custody for more than 10 years, and remedy of appeal would be meaningless if he had to remain in custody for full term. So, this present appeal was by the appellant. The Honorable Court, Supreme Court, went into the full details of the cause, why the appeals are taking so much time, what should be done, which direction should be given. So, while disposing of the appeal, it said that it directed the ministry to present at least quarterly reports on strikes or abstaining from work, loss caused, and required action to be proposed. It said that the matter could be considered in its contempt or inherent jurisdiction of the High Court and even by the Supreme Court. The court may hold that office bearers of the Bar Association, even Bar Council, who pass resolution for strike or abstaining for work, to be liable, to be restrained from appearing before any court for specified period or until such time they purge themselves of contempt to the satisfaction of the Chief Justice of the concerned High Court based on his appropriate undertaking or conditions. And even the Honorable Court directed that they might also be considered and liable to be removed from positions of the office bearer of the Bar Association forthwith until Chief Justice of the High Court so permits on appropriate undertaking being filed by them. Matter might also be considered by the present court on receipt of report from High Courts in this regard if they are unable to do some positive action. So even this Honorable Supreme Court can consider the matter. That did not debar report petition from any other source to take proper decision. Based on second direction was, based on Law Commission report, concerned authorities might examine whether there was any need for any change in judicial structure by creating appropriate platform to decongest constitutional courts so as to realistically achieve constitution goals of speedy justice. There was need to consider whether there should be a body of full-time experts without affecting independence of judiciary. So separation of power is to be organ is to maintain so as to assist in identifying, scrutinizing, and even the evaluating candidates, firstly at the pre-appointment stage, and then to evaluate performance post-appointment. So there were a lot of other observations. I am keeping my video little bit short so that you may not feel tired. Thank you all. I hope you are enjoying my videos. So friends, be connected with my channel. I am daily working for 2 to 3 hours for our legal fraternity to update them on the different ratios. We all know that law is dynamic. So there are changes, there are developments every day as per needs of the society by our Honorable Supreme Court by remaining within the contouring of our Constitution. So please be connected. Don't forget to subscribe, share. If you feel that I should improve my way of expressing, you are free to send me message. I will try to adopt that. Till that, thank you all for seeing this video. God bless you all. Have a nice day. Thank you.